Good evening. To give a lecture named for Justice Ruth Bader Ginsburg to this august assembly is an extraordinary honor, and to do so in her company is simply a joy. Justice Ginsburg, your significance to my professional fields, civil procedure, constitutional law, gender in the law, is simply unparalleled. Your place in my own life includes pivotal encouragement when you joined the appellate bench. Later, you made a memorable phone call to me telling me you had nominated me to serve on the board of the American Bar Foundation after asking if I was a member of the bar. That was an affiliation that changed my research and my relationship with the bar. I will never forget your support as I decided to entitle an article, Justice Engendered. And I said, "You think that's too bold?" And you said, "Go for it," even if it was in the Harvard Law Review. Your example as a short Jewish woman whose work opens the literal and professional doors I have been lucky enough to enter, and your repeated kindnesses mean more than I can say. I want to take a moment also to salute Marty, who I know loved this event and who remains a beloved, distinguished graduate of my school, as well as someone who cooked one of the few good meals I had when I was a law clerk. So I give my deep thanks to the New York City Bar for this honor, and also note what a delight it is for me to be here with so many distinguished people, friends, colleagues, former students, and people I want to meet. I turned this night with this puzzle, and I ask you to think with me about the origin of this puzzle and its future. The puzzle is this: why, when there has been a surge of educational initiatives separating students by sex or gender in the United States right now, why now? Why is this happening after decades in the United States have brought dramatic transformations in the legal treatment of women, opening educational and professional opportunities? During my lifetime, indeed since I went to college, reforms have opened education, professions, careers, and institutions to women. It's been palpable and thrilling, though there's much more to be done. Here's a vivid example. When I graduated from law school, there had never been a woman on the Supreme Court of the United States. Now there are 3, one, of course, being this lecture's namesake. And yet here's the puzzle. The last decade has brought a sudden and growing revival of single-sex education. To consider this puzzle, I will offer 2 stories of gender in the law, stories that touch on my life and Justice Ginsburg's life, and then invite us together to explain the puzzle and assess this moment. So 2 stories. The first is the story of advances in the direction of gender equality in education and the professions. In the past 50 years, there are few aspects of American society undergoing more change than women's place in education and the professions. The speed of change is itself remarkable. Margaret Thatcher in 1971 said, "I don't think that in my lifetime there will be a woman prime minister." She became, of course, Great Britain's first woman prime minister 8 years later. It's been a time of prodigious change. When I was a child, there was a riddle that truly stumped people. It asked, how could it come to pass that a young person who was injured is delivered to the hospital by his father? You remember this? And then he's met there by an aghast surgeon who says, "But I can't operate on my own child." And the thing is, we didn't get what this was asking. Neither I nor others immediately guessed that the surgeon was the child's mother because we didn't know. We didn't know surgeons who were women. We didn't know women who were clergy or CEOs of major companies. I did know one woman lawyer. I had a cousin whose name was Martha. She became a lawyer, but she did so after she was divorced. So that absolutely made clear that you don't do that unless things are really bad. Just as I was learning what a lawyer was, Justice Ruth Bader Ginsburg was admitted to the Harvard Law School after her stellar record at Cornell. She gave up her admission, though, to join her husband Marty, who was already a student there as the military called him to serve in the reserves. The school welcomed Marty back immediately when he was done with his service, but Ruth, who'd already been admitted, had to reapply. Readmitted, she joined 8 other women in the fall of 1956 in the class behind her husband. When Marty became ill with cancer, Ruth organized his studies and typed his papers while continuing with her own work. Marty recovered, graduated, accepted a job in New York. The family, including by then young Jane, moved to New York, and Ruth Ginsburg asked the dean of the Harvard Law School, could I finish out my last year at Columbia but get my degree at Harvard? And the dean of the Harvard Law School said no, something that deans of the Harvard Law School have regretted ever since. She made law review at Columbia. A fellow student there described her as scary smart. She graduated in a tie for the first in the class of 1959. She clerked, as we heard, for a federal judge. She became a researcher of the Swedish legal system in a program funded by the Carnegie Foundation, one of the first women law professors in the country. Her CV does not, however, report the interviews that were refused, the jobs that were foreclosed along the way by such notables as Justice Felix Frankfurter. By 1970, Professor Ginsburg had started teaching a course on women in the law and began to work with the ACLU to challenge legally enforced gender discrimination. I entered college in 1972. That was precisely the year that Congress enacted Title IX, banning sex discrimination in schools that receive federal aid. That was the year Congress sent the Equal Rights Amendment to the states for ratification, and the Supreme Court ruled that the right of privacy protecting access to contraception extended to single as well as married people. And that was the year that Ruth Bader Ginsburg began her representation of Stephen Weisenfeld. The Social Security Administration had denied him the parental benefit despite his wife's contributions to Social Security. Lawyer Ginsburg argued that not only did this denial of the mother's insurance benefit treat a man worse than a woman, it also treated the woman who had contributed to the social insurance program unequally compared to a male contributor when benefits came due. The Supreme Court agreed unanimously in 1975 in one of the milestone cases Justice Ginsburg established on the journey to enforce equal protection in the context of gender. As that case and others pended, I was a fairly carefree college student. I wanted to attend a school where being a woman was not an issue. I found it at the University of Michigan. Women had attended there since 1870. I didn't have to prove it to anyone. Like other women at the time, I faced remnants of bias against women, but I also benefited from emerging efforts to rectify it. My university nominated me for a Rhodes Scholarship, although they had never given any to women, and they didn't give one to me. I guess I was a test case. The interviewers asked me, how will you have a career and raise a family? I replied, my father did it. The following year, the selection committee did award its first scholarship to women. I've had the privilege of being the first woman to do various things, but even better, the great privilege of not being the first, as in not being the first woman dean at the Harvard Law School. My own biography hence mirrors larger national developments. In 1967, Lyndon Johnson added gender discrimination to his affirmative action executive order, directing federal agencies and contractors to take active measures to ensure for all the same educational and employment opportunities as for white males. The Equal Employment Opportunity Commission outlawed sex-segregated help want ads in newspapers in 1968, and the Supreme Court agreed 5 years later. Congress banned discrimination in employment on the basis of pregnancy in 1978. So many of these changes came about because Ruth Bader Ginsburg's ACLU Women's Rights Project won pivotal victories, notably decisions in Reed v. Reed, Frontiero, so forth. All male educational colleges and universities opened their doors to women in the 1960s and 70s, and during this period, women increasingly entered law schools and the legal profession. In 1967, only 5% of law school enrollments nationwide were female. This would grow to 8% in 1968, 30% in 1970. 2011, it hovers around 50%, in some places more. During the same period, women enrolled in medical schools. Now it's over 52%. In 1982, the Supreme Court rejected the exclusion of a student from a state-supported higher educational program on the basis of gender. It was a case brought by a man seeking entrance to an all-female state nursing school. For my own daughter, now a college freshman, these events seem, like much of her mother's life, like ancient history. That sense of naturalness of the new order is itself a sign of how far we have come. That's story one. Story two. Because story two tells of the revival of single-sex education, it has to start earlier with its early rise and fall. Distinctive treatment of girls and women stems from long-standing beliefs bestowing on girls and women, really white girls and women, a special place in home and family, a private realm imagined as separate from the public realms of boys and men. In the 17th century, education for girls in North America rarely moved beyond home instruction or at best primary school. Colleges and schools preparing students excluded girls. By the late 18th century, a few boarding schools started for girls, but they focused on refinements like music and art, and not subjects like science and math. The push for basic public education in this country, starting in the 1840s, included an argument about whether it should be coeducational. Opponents warned that boys would be too coarse and would corrupt the girls. Single-sex education, they said, better suited the differences between boys and girls. Early advocates for women's rights agreed that boys and girls were really different, but that's why there should be coeducation, they argued, because girls would civilize the boys. Turned out it was cheaper to have coeducation. So coeducation became the norm for public education in this country. In the late 19th century, ostensibly scientific and moral rationales for excluding women from legal and medical education persisted. The most elite private schools and colleges remained single-sex and typically excluded blacks, Jews, recent immigrants. But coeducation remained the norm for public schools, even when public school expanded to include high school. The Supreme Court's decision in Brown versus Board of Education, high point in the struggle for racial justice in the 20th century, at least from the court's point of view, carried significant repercussions also for the treatment of gender in schools. Activists cited Brown's rejection of separate but equal instruction in the context of race. They challenged the use of gender to sort students into different classrooms or schools. Proponents of gender equality also at times defended all-girl instruction as a kind of remedial empowerment measure meant to be temporary. The 1964 Civil Rights Act enlarged Brown's rejection of state-mandated exclusions beyond schooling, beyond government-run institutions, and beyond race-based exclusions. The growing movement for women's rights successfully propelled the 1972 Education Amendments, producing Title IX, which conditions the use of federal funds for educational programs on individual legal protections against gender discrimination. And advocates used that law to equalize resources across programs for boys and girls and also to open up male-only educational settings. Yet Title IX expressly excluded from its coverage the admission policies at secondary schools and colleges that traditionally enrolled only students of one sex. By exempting school admissions from protections against gender discrimination, the legislators indicated an enduring belief that differential treatment by gender is not necessarily derogatory or negative. Even advocates and scholars committed to combating discrimination have disputed the analogy between race and gender, especially around the issue of whether separate can ever be equal. Gender has an undisputed biological basis. Racial differences do not.